if someone is pondering a protective order in the FAPA context, in the Family Abuse Protection Act context, what should they be keeping in mind when they go to court? What's the process look like? How do they get one of these orders to begin?
Yeah, so the first thing that they would do is there's a couple of pieces of paperwork that they'd have to fill out, mostly just regular information. So they'd have to fill out the original petition for the restraining order, and they'd have to describe an incident of abuse in the last 80 days because that's one of the elements. And then they'd also
How many days?
sorry, 180 days, so a half year. And so they have to show that there was at least one incidence of physical violence or abuse in the past 180 days. And that's, I mean, just a bare minimum. We've seen cases where they have very good reason to be scared and very good and credible reasons to be scared, but there's no incident of violence. And so it dies right there.
Yeah, so you got the 180-day range is important. So somebody may have waited too long and they had 181 days ago, there was something that was clearly physical abuse. And the only allegation within the last 180 days is maybe actions that didn't involve any touching.
Sometimes horrible actions too.
And some of those horrible actions do meet the statute because the statute for abuse, you have actual bodily injury,
Mhm.
right? You have attempted bodily injury, which means intentionally trying to cause bodily injury, like a swing and a miss would
Mhm.
be an attempt. Me turning and accidentally um, almost bumping someone would not be an attempt. Maybe that would be negligence, or maybe it'd be reckless bodily injury, because the elements matters with the state of mind: intentional, knowing, and reckless. Right. So if intentionally cause bodily injury or recklessly cause bodily injury, like a reckless causing a bodily injury might mean I'm, trying to scare somebody and I'm doing this and then, oops, I didn't pull my punch quick enough and I hit somebody. Didn't intend to do it. I intended to scare them. Well, that's reckless. But it's also putting someone in fear of imminent bodily injury, which is also an element that can qualify for abuse in the last 180 days. So I think it's real important that people have a long list of everything that they have. Anything before the 180 days should still be alleged.
It's still there's a place on the FAPA petition that actually says, please list any instance that happened before 180 days.
And why is that? Why is that important?
Well, because sort of what you were talking about a little bit earlier about, the person who takes off their wedding ring whenever they're about to commit violence, the instance that happened prior to that can be relevant for state of mind. It can be relevant to know about the party's relationship and other things like that and what happened before.
And also, there's two other elements about imminent abuse and credibility, credible threat. And the more bad acts prior to the 180 days, the more credible the threat and more likely for imminent abuse if you don't have a restrainer or an effect. One isolated incident in 100, even within the 100 days, you could have an isolated incident where you put somebody in fear of imminent bodily injury, and a court could find that that's not grounds for a restraining order because it's not a likelihood of continued abuse or it's not a credible threat. But if they would have put in a history of abuse that it was prior to the 180 days, and still got to go to trial and prove it. But just to get through that initial threshold, it's important to put as much information there as possible that lists the bad acts that a reasonable person would look at and be like, okay, there's some sort of control going on here that sets up the context for this isolated incident that maybe in a vacuum might not be very frightening, but given the history is.
Absolutely, yeah. And so what happens is that you'd fill out that form. It's like petition for the restraining order, and that's the main form that you're going to fill out. Then you're also going to fill out what I believe is labeled the CIF or confidential information form, basically just asking for your information and then the other party's information. And you're going to, so you file you fill out the petition, and it's relatively straightforward. There's questions if you have kids with the other person, they're going to ask about that. They're going to ask basically what you want to be because you're petitioning for the restraining order. They're going to ask what you want to be on the restraining order, whether you want the other person excluded from certain property or something like that. And then you file the confidential information form, the petition, and then potentially any other form that your county requires, since they can all be a little bit different. And then what happens is that you take it to a judge ex parte, which means that the other party isn't there. You take it to the judge, and the judge potentially asks you questions or discusses the case with you. And if the judge rules in your favor for this particular at the ex parte hearing, the judge will sign the restraining order, and the restraining order will be in effect But just because it's in effect does not mean that it's going to be permanently in effect, because the other party has the right to demand a show cause hearing and defend themselves and argue as to why the restraining order should not be put into effect. And so it's kind of a two-pronged thing. There's going to be two hearings that you go to if you are the petitioner. The first one, you fill out the paperwork, you get them to the judge, you and the judge talk about it yourselves, the other party isn't there. And then the restraining order's put in place. The judge will fill out a different form that where he or she signs their initials and adds there are certain things that they can either enforce or not enforce depending on the particular order. And then after they enforce that order, after the other party is served, the other party has the right to request a show cause hearing.